My mother died on a Tuesday afternoon in March. By Wednesday morning, my Aunt Carol was already at the house with 3 suitcases, a real estate attorney she'd clearly retained weeks earlier, and a story about how Mom had promised her everything. I want to pause here for 1 second. If you're new to this channel, I tell real, detailed stories about betrayal, justice, and the moments when people get exactly what they deserve. Hit subscribe and the notification bell, because this one doesn't go where you think it's going. Now back to the story. Mom passed from pancreatic cancer. 6 weeks from diagnosis to the end. She went fast, which in some ways was a mercy, and in other ways left a crater the size of a small state in the middle of my life. Her name was Diane. She was 61. She'd been a high school English teacher for 32 years in a suburb outside Columbus, Ohio, Westerville, if you want the real geography of it. She and my father had bought the house on Greenfield Lane in 1994, right after I was born. 3 bedrooms, a finished basement, a backyard with a dogwood tree Mom planted the year I turned 5. Dad died of a heart attack when I was 19. He'd been a structural engineer. Quiet man. Good man. Mom never remarried, never even dated seriously after him, and she used to joke that he'd ruined her for anyone else. I think she meant it. The house was paid off. Completely. Dad had been obsessive about that. He'd refinanced twice in the early 2000s to shorten the term, and by 2008, there was nothing left but property tax and maintenance. Mom had also accumulated a retirement portfolio through her teacher's pension, some index funds she'd managed herself with the help of a financial advisor named Gary Pulaski, and a life insurance policy through the school district worth $250,000. None of this made her wealthy by any stretch, but it made her comfortable, secure, and that was everything to her after Dad died. She told me more than once, the only thing worse than losing your husband is losing your home on top of it. So she made sure that wouldn't happen. When Mom was diagnosed in late January of that year, she didn't waste a single day being sentimental about it. She was practical. She was organized. She sat me down at the kitchen table, the same kitchen table where I'd done homework since 2nd grade, and she said, "I need to go over some things with you, Nina." I remember the light that afternoon. Gray Ohio winter light. The kitchen smelled like the lemon tea she drank constantly during chemo. She had a manila folder, and inside it was everything. The will, updated 18 months earlier by her attorney, a woman named Sandra Kohler, who operated out of a small office on North High Street. The deed to the house, already in Mom's name solely. The beneficiary designations on every financial account. The insurance policy. Contact numbers for Gary Pulaski. A handwritten letter she'd written to me, sealed in an envelope, that she said I should open when things settle down. The will was straightforward. Everything went to me. The house, the retirement accounts, the insurance payout, the contents of the house, her car, a 2019 Honda Civic with 42,000 miles on it. There was a small bequest, $5,000 to the Westerville Public Library where she'd volunteered for 15 years, and $5,000 to the animal rescue where she'd adopted both of her cats over the years. That was it. No ambiguity. No complicated trusts. No conditions. Sandra Kohler had drawn it up cleanly. Mom had signed it in front of 2 witnesses, and it had been filed with the Franklin County Probate Court. Mom looked at me when she finished going through it all and said, "Carol is going to have a problem with this." I didn't know what she meant at the time. Or maybe I did, and I just didn't want to believe it. Carol was Mom's younger sister by 4 years. She lived in Newark, about 40 minutes east of Columbus, with her husband, my Uncle Frank. They had 2 sons, my cousins, Derek and Troy, who were in their mid-30s at the time and who I'd grown up seeing at Thanksgiving and Christmas and occasional summer barbecues. Carol was a real estate agent. Frank did something in logistics. I never fully understood what. They were fine. They were family. I didn't have any deep beef with them. Carol and Mom had the kind of sister relationship that looked warm from the outside, but had these small, sharp edges if you paid attention. Mom would mention offhand that Carol had asked to borrow money again, or that Carol had made a comment about Mom being lucky Dad had left her in good shape. Little things. Little digs. I filed them away without thinking much about it. But Mom knew. She must have known for years, maybe decades, that Carol carried some deep resentment about the life Mom had built. Carol had married Frank young, had the boys young, had never finished her degree, and had spent most of her adult life in a house that was always one unexpected expense away from serious trouble. Mom, by contrast, had her career, her pension, her paid-off house, her quiet stability. And Carol, whether she admitted it or even fully understood it herself, had been quietly seething about it for a very long time. Mom told me that afternoon in the kitchen, Carol's going to say I was pressured. She's going to say I didn't know what I was doing. She's going to say that your father would have wanted the family to share. None of it is true, Nina. But she's going to say it. I asked Mom if she wanted to change anything. Add something for Carol. Just to avoid the fight. Mom shook her head. I've thought about this for a long time. Everything in this house, I built it with your father. Everything in those accounts, I earned it, or he earned it, and we saved it together. Carol has her own life. Her own choices. I love her, but I am not responsible for the fact that she and Frank have never been careful with money. And I am not going to rewrite my will to appease someone who has spent 20 years making me feel guilty for being okay. She paused, sipped her tea, winced, even the tea hurt by then. I'm leaving this to you because you're my daughter. Because you were here. Because you took care of me when it mattered. Not because I don't love Carol, but because love and obligation are not the same thing. I didn't argue with her. I just held her hand and told her I understood. 6 weeks later, she was gone. The funeral was on a Saturday. Small. Maybe 60 people. Mostly teachers from Westerville High, some neighbors, a few friends from her book club. Carol and Frank were there. Derek came. Troy didn't. He was out of town for work, which I later learned meant he was on a golf trip in Myrtle Beach. That should have told me something about where things were heading, but I was too deep in grief to read the signals. Carol cried at the service. Real tears, as far as I could tell. She hugged me tight and said, "She was the best of us, Nina." She really was. I believed her. Or I wanted to. The reading of the will happened the following Tuesday at Sandra Kohler's office. Me, Carol, Frank, and Derek. Sandra was professional, thorough, and unambiguous. She read every line of the will aloud, explained the probate process, confirmed that the will had been properly executed and filed, and stated clearly that I was the sole beneficiary of all listed assets. She also mentioned that the will had been updated recently, December of the previous year, about 2 months before Mom's diagnosis, and that Mom had been fully lucid, fully aware, and fully intentional during the process. Sandra had notes from the meeting. She had the witness signatures. Everything was clean. Carol sat very still during the reading. Her face didn't change. Frank shifted in his chair a few times and kept looking at Carol like he was waiting for a signal. Derek stared at his phone, then looked up abruptly when Sandra said sole beneficiary, and the name on the document was mine. When Sandra finished, there was about 15 seconds of silence. Then Carol said, very calmly, "I'd like to see the previous version of the will." Sandra told her that the previous version, from 2011, was also on file and left everything to me as well, with the addition of a small bequest to Carol that Mom had since removed in the update. Why was it removed? Carol asked. Your sister chose to revise her estate plan, Sandra said. She was within her rights to do so, and the revision was executed with the same formality as the original. I'd like to contest this, Carol said. Sandra nodded like she'd expected nothing less. That's your right. You would need to file a petition with the probate court. I'd recommend you retain your own counsel if you intend to pursue that. I sat there and said nothing. Not because I was being strategic yet. I was just stunned. My mother had been dead for 9 days. The funeral flowers were probably still fresh in the living room, and my aunt was already lawyering up. We left Sandra's office and walked to the parking lot. It was cold, that particular Ohio cold that cuts through your jacket and sits against your ribs. Carol stopped me before I got to my car and said, "Nina, I'm not doing this to hurt you. You know that, right?" Mom was not herself at the end. She was on heavy medication. Sandra took advantage of a dying woman. I looked at Carol. I really looked at her. She was 57. She had Mom's eyes, same brown, same shape, but harder somehow. Like the softness had been worn away by years of comparing her life to Mom's and finding herself wanting. She updated the will 2 months before her diagnosis, Carol. Then she was already sick and didn't know it. Pancreatic cancer doesn't appear overnight. She wasn't sick in December. She was fine in December. She was healthy. She was 61, Nina. She'd been grieving your father for how long? This was the moment. The fork. I could have argued. I could have gotten angry. I could have screamed at her in that parking lot. Instead, something shifted in my chest, not calmness exactly, but a kind of cold clarity. Like a door closing quietly. I said, "I'm not doing this with you today." I got in my car and drove home. To Mom's house. My house, now legally. Carol called me that night around 9 o'clock. I let it ring to voicemail. She left a message. Her voice was softer this time, almost pleading. "Nina, please don't shut me out. We're family. We can work this out without lawyers. I just want what's fair." I didn't call her back. She called again the next morning. I didn't answer. She texted, "Can we talk? I want to come by the house." I stared at that text for a long time. The house where I was sitting on my mother's couch, surrounded by my mother's things, still smelling like my mother's lemon tea. And this woman, my mother's sister, wanted to come by and talk about what was fair. I texted back, "Give me some time, Carol. Please." She didn't give me time. Thursday morning, 3 days after the will reading, I woke up to the sound of a car door slamming in my driveway. I looked out the front window and saw Carol's silver Lexus. She was getting out. Frank was in the passenger seat. And behind them, in a black Nissan Altima I didn't recognize, was a man in a gray suit I'd never seen before. I opened the front door before they could knock. Carol smiled. That rehearsed, pleasant smile she used at holiday dinners when she wanted something. "Nina, honey, I brought someone I'd like you to meet. This is Dennis Hargrove. He's an attorney." Dennis Hargrove extended his hand. I didn't take it. "I know who he is," I said. "Or I know what he is. You brought a lawyer to my mother's house 4 days after we buried her." Frank stepped forward. "Nobody's trying to intimidate you, Nina. We just want to talk. You want to talk, you can call. You want to bring an attorney to my front door at 8 in the morning, you can leave." Carol's smile dissolved. "You're acting like I'm the enemy. I'm your family. Mom was my sister. I have rights too." I leaned against the doorframe. "You have the right to file a petition in probate court. You have the right to retain counsel. You do not have the right to show up at my house uninvited with a stranger and act like this is a negotiation." Dennis Hargrove, to his marginal credit, stepped back and said, "Carol, maybe we should give her some space." Carol ignored him. She looked past me, into the house, and said something that lodged itself in my brain like a splinter. "This house should have been half mine anyway. Dad bought it for both of us. She just ended up with it because she was the one who stayed." I closed the door. I stood in the foyer for maybe 2 full minutes, not moving. Then I went to the kitchen, poured myself a glass of water, and sat down at the table. The same table. And I started thinking. Not emotionally. Not with the grief I was drowning in every other hour of the day. I thought about it the way Mom would have, practically, methodically, like she was grading a stack of essays and looking for the through line. Carol had mentioned Dennis Hargrove's name. I looked him up. He was a probate and estate litigation attorney based in Columbus. He'd been practicing for 22 years. He had a reputation for aggressive estate contests. I found 3 published cases where he'd represented family members challenging wills, and he'd won 2 of them. One of them, from 2019, involved an adult child contesting a mother's will on grounds of undue influence by a caregiver. He'd gotten the will thrown out and the estate redistributed. That scared me. Not because I doubted Mom's will was valid, it was ironclad. Sandra Kohler had done everything right. But I knew that a contested probate case could drag on for months, even years. It could cost tens of thousands in legal fees. It could freeze the estate assets, meaning I couldn't touch the house, the accounts, or the insurance money until it was resolved. Carol knew this. Dennis Hargrove certainly knew this. The strategy wasn't necessarily to win, it was to make the process so expensive and exhausting that I'd give in and settle. That night, I called Sandra Kohler. She answered on the second ring. "I've been expecting your call," she said. "Carol brought a lawyer to my house today. Dennis Hargrove." A pause. "I know Dennis. He's competent. He's also expensive, which means your aunt is either serious or has someone backing her financially. She mentions something about the house being half hers because my grandfather helped buy it. That's not how property law works, and she knows it. Your mother and father held title jointly, and upon your father's death, full title passed to your mother by survivorship. Your grandfather's contribution, if there even was one, has no legal bearing on the current ownership. Carol would need to prove that your mother lacked testamentary capacity, or that someone exerted undue influence on her when she executed the will. Both are extremely difficult to prove when the testator was lucid, the witnesses are credible, and the attorney who prepared the document is available to testify. So, what do? First, we wait for her to file. She's entitled to file a contest, and the court will set a timeline. In the meantime, I'd recommend you do something that might feel counterintuitive. What? Don't shut her out. Let her talk. Let her come around. Be polite. Be present. Because people who are trying to build a case against you will eventually show you exactly what they're planning, if you're willing to listen. Sandra paused again. And Nina? Start keeping records. Everything. Texts, emails, voicemails, conversations if you can. If Carol is going to claim your mother wasn't in her right mind, it would be very useful to have evidence that Carol herself knew otherwise. I sat with that advice for a long time after I hung up the phone. Start keeping records. 2 days later, Carol filed her petition. The petition landed in Sandra's office on a Friday afternoon. I know because Sandra called me at 4:47 that evening. I remember looking at the time on the microwave clock in Mom's kitchen. And her voice had that particular flatness that lawyers use when they're delivering bad news, but trying to sound like it's just business. She's filed a formal contest, Sandra said. Grounds are lack of testamentary capacity and undue influence. She's claiming that you, and I quote, isolated Diane from her family during her final weeks and exploited her vulnerable state to redirect assets away from her natural heirs. I almost laughed. Not because it was funny. Because it was so perfectly, transparently false that it circled back around to being almost impressive. I had been at Mom's house every single day during those 6 weeks. Carol had visited twice. Derek had visited once. Troy hadn't visited at all. And now Carol was going to stand in front of a judge and claim that I was the one who'd isolated Mom from her family. What happens now? I asked. The court will schedule a hearing. Probably 60 to 90 days out, given the backlog in Franklin County probate. In the meantime, the estate is effectively frozen. The house, the financial accounts, the insurance proceeds, none of it can be distributed until the contest is resolved or withdrawn. How long could this take? Sandra was quiet for a moment. If she pushes it, and if Hargrove is as thorough as I think he is, it could take a year. Maybe longer. These cases are emotionally driven, and emotional clients don't settle easily. A year. I was 28 years old. I had a job as a project coordinator at a marketing firm in downtown Columbus, making $52,000 a year. I had a small apartment in Grandview Heights that cost $1,150 a month. I had about $8,000 in savings. And my mother's entire estate, the house, the retirement accounts, everything was locked in a legal freezer because my aunt decided that her dead sister's will wasn't convenient for her. I didn't sleep that night. Not because of the legal timeline. Because of the phone call I got at 11:30 p.m. Carol. I almost didn't answer. But something made me pick up. Maybe it was the same instinct that Sandra had described, the one that said, let her talk. Let her show you what she's doing. Carol's voice was different on the phone. Softer. Almost maternal, which was bizarre, because Carol had never been maternal toward me in my entire life. She said, Nina, I know you're upset. I know this feels like an attack. But I need you to understand, I'm not trying to take anything from you. I just want what Mom would have wanted if she'd been thinking clearly. I didn't respond. I reached over to my nightstand and opened the voice memos app on my phone. I tapped the red circle. Carol, I said, what exactly do you think Mom would have wanted? Oh, Nina, come on. You know she loved all of us. She would never have cut me and the boys out completely. That's not who she was. Dennis says that the chemo drugs, the pain medication, they change how people think. They make people paranoid, isolated. Mom wasn't herself those last few weeks, and you were the only one there. You were the one feeding her information. You're saying I manipulated my dying mother. I'm saying you were in a position to, and I think you may have done it without even realizing. People do things under stress that they don't understand. I'm not saying you're a bad person, Nina. I'm saying the will doesn't reflect Mom's true wishes. I asked the question that I already knew the answer to. Carol, did Mom ever tell you, at any point, in any conversation, that she wanted to leave you part of the estate? A pause. Then, she told me years ago that the house would be half mine. She promised me, Nina. When Dad died, she said the house belonged to both of us. That was a lie. I knew it was a lie because Mom had told me the opposite explicitly, and because there was no legal basis for the claim. But what mattered in that moment wasn't whether it was true. What mattered was that Carol had just said it out loud into my phone while I was recording. Okay, Carol, I said. I hear you. I hung up. That was the first recording. March 17th, 11:34 p.m. 18 minutes long. I listened to it back the next morning while I was getting ready for work, and I could hear everything, the false warmth, the calculated framing, the way she kept using words like fair and family and Mom's true wishes like they were items on a checklist. I called Sandra and told her about it. Good, Sandra said. Keep doing that. Every conversation, every phone call, every interaction, if you can record it legally, record it. Ohio is a one-party consent state. That meant as long as I was a participant in the conversation, I didn't need Carol's permission to record it. I verified this with a quick consultation with a second attorney Sandra recommended, a man named David Chin who specialized in estate litigation and who confirmed that not only were the recordings legal, but they could be admissible as evidence if the court found them relevant and authentic. So I started recording everything. Not obviously. Not with some hidden microphone taped under the kitchen table. I just kept my phone in my pocket or sitting on the counter or on the coffee table with the voice memos app running. I did it at every family interaction for the next 24 months. Every dinner. Every phone call. Every accidental visit from Carol or Frank or Derek. Every argument. Every threat. Every moment where they thought they were speaking privately and were, in fact, building the case that would eventually bury them. Carol's visits to the house started about 2 weeks after she filed the petition. She showed up on a Saturday afternoon with a casserole dish and a smile, like nothing had changed. Like she hadn't just sued me in probate court. I let her in, because Sandra had told me to. I made tea. I sat at the kitchen table and let Carol talk. And she talked. God, she talked. She talked about how Mom had always said the house should be shared. She talked about how Dad had promised their parents that he'd take care of Carol. She talked about how Mom's pension should rightfully be split among the siblings because Diane wouldn't have had that career if our parents hadn't pushed her through school. She talked about how I was young enough to rebuild, and she and Frank were approaching retirement with nothing. Every word of it went onto my phone. Frank was less chatty, but more dangerous in a different way. He had this habit of making comments when he thought the conversation was casual, like he was just thinking out loud. One afternoon in May, he was standing in my living room looking at the bookshelves, Mom's bookshelves, filled with her collection of novels and teaching resources, and he said to Carol, in what he clearly thought was a private aside, but was loud enough that my phone on the coffee table caught every syllable, "The appraiser said the house is worth at least $385. If we can get Nina to settle for half, that's close to $200,000 right there. Plus the retirement accounts split 4 ways. That's another, what, 70, 80,000 each? This could actually work out." Carol shushed him. Frank, not here. But it was there. Recorded. Date stamped. May 14th, 3:22 p.m. Derek was the wild card. He was 36, worked in commercial roofing sales, and had his mother's gift for saying the worst possible thing at the worst possible time while sounding completely reasonable. He came to the house alone one evening in June. I think Carol sent him as a scout, someone to feel out my emotional state, and he sat on the back porch with me while the dogwood tree Mom planted swayed in the warm air, and he said, "Nina, honestly, I don't even care about the money. I just think it's messed up that you're keeping all of this to yourself when Mom clearly loved all of us. Like, you get the house, the money, the insurance, everything, and Troy and I get nothing? That doesn't seem like something Mom would do." I asked him, "Derek, how many times did you visit Mom in the 6 weeks she was sick?" He looked at me, looked away. "That's not the point. How many times?" "Twice. I went twice. Troy went once. Carol went twice. I was there every single day. I took her to chemo. I picked up her prescriptions. I slept on the couch in the living room the last week because she didn't want to be alone at night. So when you say Mom clearly loved all of us, you're right. She did. But love and presence aren't the same thing, and her will reflected who is actually here." Derek was quiet for a while. Then he said, "You know, Aunt Nina, you're making this way harder than it needs to be." "How am I making it hard?" "I didn't file a lawsuit. Your mother did. My mom's just trying to get what's fair. And honestly, if you just agreed to split it from the beginning, none of this would be happening. You're the one dragging it out." I let that sit there for a moment. The audacity of it, the sheer, frictionless ability to reverse the entire narrative so that I, the person who had been sued, was somehow the one dragging it out, was almost impressive. "Is that what your mom told you to say?" I asked. Derek stood up. "I came here to be reasonable. But you clearly don't want to be." He left. His car tires crunched on the gravel driveway. I went inside and checked the recording. 26 minutes. Clean audio. And right there, at the 22-minute mark, Derek had said, unprompted, "My mom's just trying to get what's fair," which directly contradicted the legal claim in Carol's petition that the contest was about Mom's true wishes and not about money. He'd confirmed on recording that the entire lawsuit was financially motivated. I was starting to understand what Sandra meant when she said people will show you what they're planning if you let them. The summer of that first year was the hardest. Not because of the legal battle, that was mostly filing and waiting, but because of the emotional corrosion. Carol started showing up at my workplace. She didn't come inside, but she'd sit in the parking lot of my office building and wait for me to come out, then approach me with questions about the estate. My coworker, a woman named Becca who I'd been friendly with, asked me one afternoon, "Is that your aunt? Because she's out there again. 3rd time this week." I had to explain the situation to my boss, a decent man named Roger, who told me, if she comes on the property again, call building security. But Carol was smart enough to stay on the public sidewalk. She knew exactly where the line was. In July, Carol called my landlord. I don't know how she got the number, probably looked it up through county records. She told my landlord, Mark, that I was going through a difficult legal situation and that there might be issues with her ability to pay rent going forward. Mark called me the next day, concerned, and I had to spend 45 minutes explaining that my aunt was trying to sabotage my housing situation as leverage in an inheritance dispute. Mark was sympathetic, but also visibly uncomfortable. He told me he wouldn't renew my lease when it came up in November. He didn't say it was because of Carol's call. He didn't have to. I found a new apartment. Smaller. More expensive. In a part of Grandview I didn't like as much. But I moved, and I kept recording, and I kept showing up to the house on Greenfield Lane every day after work because that was still where Mom's things were, where Mom's cats were. I'd kept them both, a tabby named Whitman and a black cat named Dickinson. Because of course my mother, the English teacher, had named her cats after poets and where, increasingly, Carol seemed to think she had some kind of claim to being. By August, Carol had started referring to the house as the family home in every conversation. Not Mom's house. Not Nina's house. The family home. It was a deliberate linguistic shift, and I caught it immediately because I'd been trained by Mom to notice language. She used to make me annotate diction choices in The Great Gatsby for fun when I was in high school. Which sounds insane, but actually made me a better reader of people. The family home needs maintenance, Nina. The gutters are a mess. I'm taking care of it, Carol. It's a lot for one person. Frank could help. He used to help Dad with that stuff, remember? Frank can stay home. You're being selfish with that house. Mom would be ashamed. Every time she said something like that, I felt it land. Not because it was true, but because it was designed to hurt. Carol knew exactly where to push. She'd had a lifetime of watching Mom, studying her, resenting her, and she'd learned where the soft spots were. Now she was using that knowledge on Mom's daughter. But I didn't push back. I smiled. I nodded. I made non-committal sounds. And I recorded every single interaction. By October, the court had set a hearing date for the following March, almost exactly 1 year after Mom's death. Dennis Hargrove had filed a stack of motions, a request for Mom's medical records, a subpoena for Sandra Kohler's file on the will preparation, a motion to depose me, and a motion to depose Mom's oncologist, a Dr. Roshan Patel at the James Cancer Hospital. He was building a medical narrative that Mom had been cognitively impaired by her illness and medication, and that I had used that impairment to redirect her estate. Sandra told me not to worry. He's fishing. The medical records will show she was lucid. The oncologist will confirm she was of sound mind. I was there when she signed, and I have contemporaneous notes. The witnesses will testify. His case is weak on the merits. He's counting on you folding under the pressure. I wasn't folding. But the pressure was real. Between my own legal fees and the sheer psychological weight of being sued by my dead mother's sister, I was running on fumes. I'd had to take a second job, weekend shifts at a bookstore in the short north, just to cover my expenses while the estate was frozen. I couldn't touch Mom's life insurance. I couldn't touch the retirement accounts. I was living on my salary and a dwindling savings account, and every month, Dennis Hargrove filed another motion that cost Sandra billable hours to respond to. The legal fees were a deliberate strategy. I understood that now. Carol and Frank weren't trying to win on the merits. They were trying to bleed me dry financially so I'd agree to a settlement. And it was working, in the sense that I was getting per every month. But what they didn't know, what they couldn't have known, because I never told anyone, was that I had something they didn't. 7 months of recordings. And counting. The first Christmas without Mom was the worst. I didn't decorate. I didn't cook. I sat in the house on Greenfield Lane with Whitman on my lap and Dickinson sleeping on the back of the couch, and I listened to Mom's voicemails, the ones I'd saved on my phone, the ones where she called just to say she loved me, just to ask what I wanted for dinner, just to tell me about a book she'd read. There were 31 of them. I listened to all of them on Christmas Eve and cried until my throat was raw. Carol called on Christmas Day. I almost didn't answer. But I did, because I was still recording and because I needed to hear what she'd say. Merry Christmas, Nina. Merry Christmas, Carol. A pause. Then, I miss her. I know you do. I keep thinking about what Mom would want. And I can't let this go. Not because of the money. Because of what's right. There it was again. That phrase. Not because of the money. She said it every time. She said it so often that it had become a tic, a verbal tell, like a poker player who keeps touching their face when they're bluffing. Every time Carol said, "It's not about the money," it was exclusively about the money. I understand, I said. Do you? Because if you did, you'd agree to sit down and work this out like family instead of making us all go through this awful legal process. Carol, you're the one who filed the lawsuit. And I wouldn't have had to if you'd been reasonable from the start. I let the silence hang. In the background of the call, I could hear Frank's television, some football game, muffled through the wall. I could hear Carol breathing. I could hear the lie sitting in the air between us like something physical. Have a good Christmas, Carol, I said, and I hung up. I saved the recording. December 25th, 1:14 p.m. 12 minutes. By the time the 1-year mark arrived, March, a full year since Mom had died, I had recorded 47 separate interactions with Carol, Frank, and Derek. Phone calls, in-person conversations, voicemails they'd left when I didn't pick up. I had them admitting, in their own words, that the lawsuit was about money. I had Frank discussing specific dollar figures from the house appraisal. I had Carol contradicting her own legal claims, saying in one recording that Mom had promised her the house years ago, and in another that Mom wasn't herself at the end and didn't know what she was signing. I had Derek acknowledging that he and Troy had barely visited Mom during her illness. The hearing was set for March 22nd, a Friday, 12 days away. And on March 10th, Carol did something that I still think about late at night, something that crossed a line even I didn't expect her to cross. She showed up at the house with a locksmith. I was at the house on Greenfield Lane because I went there every day after work. It was a Tuesday, March 10th, about 5:15 in the evening, still light out, but that pale Ohio late winter light that makes everything look washed out. I just pulled into the driveway and was getting out of my car when I saw the white van parked at the curb. Allstate lock and key painted on the side in blue block letters. And standing on the front porch, keys in hand, was a man in a gray work shirt. Behind him, holding the front door open, was Carol. I didn't think. I just moved. I crossed the driveway in maybe 6 seconds and was on the porch before the locksmith had even turned around. Carol saw me coming and her face did something complicated, surprise, then irritation, then this quick forced smile that didn't reach her eyes. Nina. What a coincidence. I was just having the locks changed. The current ones are really worn out, and I wanted to get it done before. Get off my porch. The locksmith looked between us. He was a heavy-set guy, maybe mid-40s, and he had the expression of someone who was suddenly very aware that he was in the middle of something he did not want to be in the middle of. "Ma'am, is there a problem?" he asked me. "Yes. This woman does not own this house." "I do. And she does not have my permission to change the locks or alter the property in any way." Carol's forced smile tightened. "Nina, the estate is in probate. Technically, no one has sole ownership right now. I'm just maintaining the property. Technically, I am the named beneficiary and the executor of this estate, and you are a party to a pending lawsuit that has not been resolved. You have no legal authority to modify this property, hire contractors, or change the locks. And if that man changes one lock on this house, I will call the police and file criminal trespassing charges against both of you." The locksmith held up his hands. "I don't need any part of this. Lady, you hired me to change locks. You didn't tell me there was a dispute." He looked at me. "I'm sorry, ma'am. I'm leaving." He grabbed his toolbox and walked back to the van. Carol watched him go with a look that could have peeled paint. I pulled out my phone. I'd already been recording. I'd hit the button the second I saw the van, an instinct by now, and I held it up. "Carol, what were you trying to do just now?" She stared at the phone. She knew. She had to know, on some level, that I'd been recording things. I'd never hidden it. I always had my phone sitting out during our conversations. But she'd never confronted me about it, because confronting me would mean admitting that she was aware she was being documented, which would change her behavior. And Carol needed to behave naturally for her plan to work, or so she thought. She didn't understand that her natural behavior was the whole problem. I was taking care of the house, she said, quieter now. Someone has to. Someone does. And that someone is me. This is my mother's house. My house. And you just tried to change the locks while I wasn't here, which tells me exactly what your plan was: lock me out, claim the property, and then argue to the court that I'd abandoned it. That's ridiculous. Is it? Because it seems like a pretty clear strategy to me. And it's on recording. Carol went very still. She looked at the phone in my hand. Then she looked at me with an expression I'd never seen on her face before, not anger, not sadness, but something colder. Calculation. She was calculating whether the recording mattered, whether it could hurt her. And I could see her decide, in real time, that it couldn't. Because she didn't think I'd actually use it. She didn't think I had the nerve. She said, "You can record all you want, Nina. It doesn't change the fact that this family deserves more than what you're giving us." Then she walked to her car and drove away. I stood on the porch for a while after that. The dogwood tree was bare, it was too early for blooms. The grass was patchy and brown from winter. The house looked tired. It looked like it missed my mother. I missed my mother. And my mother's sister had just tried to lock me out of the home my parents had built together, 12 days before the hearing that would decide whether that home was mine to keep. I called Sandra. Then I called the police, just to create a paper trail. An officer came out, took a report, and confirmed that Carol had no legal right to alter the property. I had the incident documented. I had it on recording. I had it in a police report. 3 layers of evidence for something Carol probably thought was just a bold move. Sandra called me back that night. Her voice was different now. Sharper. "This changes things," she said. "The locksmith incident is useful. It shows intent. It shows she's willing to take extrajudicial action to gain control of the property, which directly contradicts her claim that this is about honoring your mother's wishes. A jury or a judge would look at that very differently." Can we use the recordings yet? Not yet. Not at this stage. The hearing on the 22nd is about whether the contest has enough merit to proceed to a full trial. Hargrove will present his evidence that your mother may have lacked capacity. I'll present ours that she was fully competent. The judge will decide whether to dismiss the contest or allow it to move forward. And if it moves forward, then we go to trial. And that's where the recordings become relevant. At trial, Carol and Frank and potentially Derek would testify under oath about their intentions and their understanding of your mother's state of mind. And if their testimony contradicts what they've said on those recordings, which it will, because they'll lie to protect themselves, then we introduce the recordings as impeachment evidence. Impeachment evidence. That was the legal term for it. You don't lead with the recordings. You let them commit to a story under oath, and then you destroy that story with their own voices. It was the difference between charging at someone with a weapon and setting a trap they walk into with their own feet. "So I need to keep recording," I said. "For as long as this takes, yes." The hearing on March 22nd went exactly as Sandra had predicted. Dennis Hargrove presented Mom's medical records, heavily redacted, cherry-picked, framed to emphasize the severity of her diagnosis and the aggressive nature of her treatment. He called Dr. Patel, who testified under cross-examination by Sandra, to his credit, that pancreatic cancer patients often experience cognitive effects from pain medication and the physical toll of the disease, but that in Mom's specific case, he had observed no signs of cognitive impairment during her appointments. He said she was one of the most organized and mentally sharp patients I've treated, and that she had specifically discussed her estate planning with him during a visit in early February, 3 weeks before she died. Sandra presented the will execution documents, her own testimony about the meeting with Mom in December, and the testimony of both witnesses. A paralegal in Sandra's office named Michelle and a notary named Robert who had been present for the signing. Both confirmed that Mom was alert, articulate, and deliberate. Michelle said Mom had brought her own notes, organized by category, and had asked detailed questions about specific provisions. The judge, a woman named Judge Patricia Moreno, listened to everything, asked a few questions, and then did something that surprised me. She didn't dismiss the case. But she didn't fully let it proceed either. She issued a ruling that Carol's petition had sufficient basis to warrant further discovery, but that she was skeptical of the claim of lack of testamentary capacity given the strength of the execution evidence. She set a trial date for 9 months out. December 4th. 9 more months. Another Christmas. Another 9 months of Carol showing up at my house, calling me, pressuring me, trying to wear me down. Another 9 months of legal fees. I left the courthouse that afternoon feeling hollowed out. Sandra caught me in the parking lot and put a hand on my shoulder. "This is actually a good outcome," she said. "A dismissal would have ended it, but a trial gives us the chance to make this permanent." If Carol had lost on the initial petition, she could have refiled with new evidence later. If she loses at trial, after a full evidentiary hearing, the door closes for good. And by then, we'll have everything we need. She paused. "How much do you have?" 63 recordings, I said. Sandra smiled. It was the first time I'd seen her smile in months. "Keep going." So I kept going. The second year was different from the first. The first year, I'd been grief-stricken, reactive, barely holding it together. The second year, I was something else. Not cold, exactly. Not detached. But focused in a way that felt almost like a physical state, like my entire nervous system had been recalibrated to a single frequency, and that frequency was patience. Carol, on the other hand, was getting worse. The partial victory at the hearing, the judge's decision to allow the case to proceed, had emboldened her. She started showing up at the house unannounced more frequently. She brought Frank. She brought Derek once. She started referring to the house in conversations as our house and the family home with even more insistence, as though repetition alone could make it true. In April, about a month after the hearing, Carol invited me to lunch at a restaurant in Worthington, a place called Martini's, one of those upscale casual spots with exposed brick and too many candles. I went because Sandra had told me to accept every invitation. "Let her think she's winning you over," Sandra said. "People talk more when they think they're persuading someone." Carol was in a good mood when I arrived. She'd gotten her hair done. It was a warmer blonde than usual, almost honey-colored, and she was wearing a nice blouse and jewelry that I didn't recognize. New jewelry. Frank's money? Or had she already started spending against the estate she didn't have yet? We ordered. She ordered a glass of Chardonnay. I ordered iced tea. She made a small face at that, like my not drinking was a personal judgment. "Nina, I've been thinking," she said, after the server left. "This whole thing has been so hard on both of us. And I really believe we can resolve it without a trial. If you just agree to a fair split, the house sold, proceeds divided equally between me, you, Derek, and Troy, we can all move on with our lives. The house isn't for sale, Carol. Everything is for sale if the price is right. The house is my home. My mother's home. I'm not selling it." Carol sipped her wine. "That's what I thought you'd say. But Nina, let me be honest with you, and I'm only saying this because I love you, and I want us to have a real relationship after this is over. The legal fees are going to eat you alive. Sandra is good, but she's not cheap. And Dennis has filed enough motions that you're going to be paying for months just to respond. How long can you afford this?" There it was. The leverage play. Carol was telling me, to my face, that the strategy was to outspend me. She wasn't even hiding it anymore. "I can afford it as long as I need to," I said. "Can you?" "I know what you make, Nina." Roger told Becca, and Becca told Derek, and Derek told me. $52,000 a year. You've got rent, a car payment, student loans. How are you paying Sandra? I felt a cold flicker of anger at the mention of Becca, my coworker, who I'd confided in, and who had apparently shared my salary information with Derek. But I didn't let it show on my face. That was the discipline now. I had learned, over the past year, that my face was evidence. Every reaction I gave Carol was something she could use, or something that could undermine me. So I gave her nothing. You shouldn't believe everything Derek tells you about my finances, I said. I'm just concerned about you. That's all. Family looks out for each other. Is that what this lunch is about? Concern. Carol leaned forward. Her voice dropped. I'm going to tell you something, Nina, and I want you to really hear it. Mom's will is going to be thrown out. I have a strong case. The medical evidence is on my side, and Dennis has found a witness, someone who saw Mom in her final weeks and is willing to testify that she was confused, that she wasn't making her own decisions. If this goes to trial, you're going to lose, and then you'll get nothing. Not the house, not the accounts, not the insurance. And you'll still owe Sandra thousands in legal fees. Is that really what you want? My heart was hammering. A witness? Someone willing to testify that Mom was confused? I didn't know who that could be, and I didn't show that I was rattled, but I was. This was new information, and it was dangerous. But Carol had just done something very important. She'd told me, on recording, that her case depended on a witness who would contradict the medical evidence and the will execution testimony. She'd told me she was going to win. She'd told me this while simultaneously claiming the lawsuit wasn't about money. The contradiction was stark, and it was captured in high-quality audio on my phone. What witness? I asked. I'm not going to tell you that. I'm just telling you that we have more evidence than you think, and it would be smarter for you to settle now. Okay, Carol. I'll think about it. I didn't think about settling. I thought about the witness. I called Sandra that night and told her everything. Sandra was quiet for a long moment. A witness, she repeated. That's a new development. It's probably someone Carol has coached, maybe a home health aide, maybe a neighbor who visited briefly. The testimony would be character evidence, not medical, but a judge might give it some weight if the witness is credible. Can we find out who it is? Hargrove will have to disclose the witness before trial as part of discovery. We'll know who it is soon enough. I waited. I kept recording. And in June, during the discovery process, Hargrove disclosed his witness, a woman named Patricia Holloway, who had been a hospice volunteer that visited Mom 3 times during her final 2 weeks. 3 visits. 15, maybe 20 minutes each. And this woman was going to testify that Mom was disoriented and easily confused and had asked her the same questions. I was at the house on Greenfield Lane that Saturday because I always was. It was still the only place that felt like home, even with the estate frozen and Carol's legal cloud hanging over every square foot of it. I was in the basement, going through Mom's teaching materials, sorting through decades of lesson plans and student projects that she'd kept in carefully labeled boxes. She'd wanted me to donate them to the Westerville School District's archive. I was doing it slowly, one box at a time, because each one was like opening a time capsule of my mother's professional life, and I wasn't ready to process it all at once. I heard a vehicle pull into the driveway. Then another. I went upstairs and looked out the front window and saw Carol's silver Lexus and, parked behind it, a white van with A1 lock and key licensed and bonded printed on the side in blue lettering. A man in a gray work shirt got out of the van. He was carrying a toolbox and a small drill case. Carol got out of her car. Frank was with her. And standing on the sidewalk in front of the house was a woman I didn't recognize, mid-40s, blonde, holding a folder, wearing the kind of bland professional smile that real estate agents wear at open houses. I met them at the front door. I didn't open it all the way. I stood in the gap and looked at Carol. What are you doing? Carol gestured toward the man from A1 Lock and Key. We're having the locks changed, Nina. For insurance purposes. Since the house is part of an active estate dispute, we need to make sure the property is secure. The property is secure. I'm here every day. You don't live here. You have an apartment. This house is unoccupied most nights. That's a liability. It's occupied right now, Carol. By me. The person named in the will. The woman with the folder stepped forward and extended a business card through the crack in the door. Hi, I'm Lori Metcalf. I'm a real estate appraiser retained by the estate. You're not retained by the estate, I said. You're retained by my aunt. The estate is represented by Sandra Kohler. She hasn't hired any appraiser. Lori looked at Carol. Carol gave her a small nod, like a handler steadying a horse. The property needs to be appraised as part of the probate proceedings, Carol said smoothly. That's standard. Dennis recommended it. Dennis doesn't represent the estate. Dennis represents you. And he has no authority to send appraisers or locksmiths to a property that is legally mine, pending the outcome of a contest that you filed. Frank stepped forward. Nina, stop being dramatic. We're not kicking you out. We're just... You brought a locksmith to change the locks on my dead mother's house 12 days before the hearing. That's not dramatic, Frank. That's a calculated attempt to take physical control of the property before the court has ruled. The locksmith, to his credit, looked deeply uncomfortable. He was standing by his van, not approaching the house, holding his toolbox like he wished it would teleport him somewhere else. I pulled out my phone. I'm calling Sandra. And I'm calling the police if you don't leave. Carol's composure cracked, just for a second. A flash of something raw and ugly crossed her face, not anger exactly, but contempt. The kind of contempt that comes from someone who believes, deep in their bones, that they deserve something and is furious at being denied. She caught herself. The smile came back. Fine. We'll do this through proper channels. But Nina? This house is going to be appraised, and the locks are going to be changed, because it's the right thing to do for the estate. You can cooperate, or you can fight every single step and make this even harder on yourself. They left. The locksmith practically ran to his van. Lori the appraiser lingered for a moment, looking at the house, then got in her car and followed them down the street. I recorded the entire interaction. I'd had my phone recording from the moment I'd seen the van pull into the driveway. The audio captured everything: Carol's claim about insurance purposes, Frank's attempt to minimize, the locksmith's silence, and most importantly, Carol's slip at the end when she said this house is going to be appraised and the locks are going to be changed. Not, we'd like to discuss. Going to be. As a future certainty. As something she'd already decided, regardless of the court's ruling. I called Sandra and played it for her over the phone. There was a long silence when it finished. Then Sandra said, I'm filing an emergency motion tomorrow morning. Request for a protective order prohibiting your aunt from entering the property or contacting any professionals regarding the property without court approval. I'm also going to attach a copy of this recording as supporting evidence. Will it work? It should. Judges don't look kindly on parties who try to physically take control of disputed assets before a ruling. It looks like bad faith. It looks like exactly what it is, an attempt to create facts on the ground. The emergency motion was filed on Monday. The judge, a man named Robert Callahan, who I'd looked up and knew had been on the Franklin County probate bench for 14 years, granted it by Wednesday. Carol was legally barred from entering the house on Greenfield Lane, contacting any appraisers, real estate agents, or contractors regarding the property, or coming within 100 yards of me outside of court-ordered proceedings. Carol was furious. She called me that night, I answered, because I always answered, and her voice was shaking. You filed a restraining order against me? Your own aunt. It's a protective order, Carol. It's about the property, not about you personally. It's about me personally. You're treating me like a criminal. Like I'm some kind of, I'm your family, Nina. You showed up at my mother's house with a locksmith and tried to change the locks. I was trying to protect the property. The property doesn't need your protection. It needs to go through the legal process, the same when you started. A long, ragged breath. Then, in a voice that was suddenly smaller, almost childlike. "I just miss her so much. And being in that house makes me feel closer to her. Is that so wrong?" And for just a moment, one terrible, treacherous moment, I almost felt sorry for her. Because I missed Mom too. I missed her every second of every day. And I understood, in the abstract, that grief does strange things to people. But then I remembered the appraiser, and the locksmith, and the phone call to my landlord, and the 47 recordings on my phone, and the small fortune in legal fees I was drowning in, and the moment passed. I miss her too, Carol. But this lawsuit isn't about missing her. And you know that. The call ended badly. Carol said something under her breath right before she hung up. I caught it on the recording, just barely. It sounded like, "You have no idea what I'm capable of." I listened to it back 3 times, and each time it sounded clearer. "You have no idea what I'm capable of." A threat? A promise? A slip? I saved it and labeled it and added it to the file. The hearing was now 9 days away. 9 days. And I was sitting on a year's worth of recordings that documented, in the participants' own voices, a pattern of financial motivation, deliberate misrepresentation, and, in Frank's case, specific discussion of dollar figures that directly contradicted the legal theory of Carol's petition. But I had a problem. The recordings were evidence, but they weren't evidence in the case yet. The case was about Mom's testamentary capacity and whether I'd exerted undue influence. Carol's recordings didn't directly address those questions. They showed that Carol was lying about her motives, but that was a different issue than whether Mom's will was valid. I needed to think about how to use them. I had a long conversation with Sandra about this. We sat in her office on North High Street, a small, tidy space with law books on the shelves and a print of a Monet water lily painting behind her desk, and I played her a curated selection of the strongest clips. The one where Frank discussed the $385,000 appraisal figure. The one where Derek admitted the lawsuit was about getting what's fair rather than Mom's wishes. The one where Carol directly contradicted herself, claiming in one breath that Mom had promised her the house years ago, and in the next that Mom wasn't in her right mind when she made the will. Sandra listened to all of it with her elbows on the desk and her fingers laced together, pressing against her chin. When the last clip ended, she was quiet for a long time. "These are powerful," she said. "But I need to be honest with you about something. The judge in this case is going to be evaluating one question. Was your mother of sound mind when she executed her will, and was she free from undue influence?" These recordings don't directly answer that question. They show that your aunt's case is motivated by money rather than genuine concern, but the court may view that as character evidence rather than substantive evidence on the capacity question. So they're useless? No, not useless. But they're not a silver bullet. What they could do, is undermine your aunt's credibility on the stand. If Carol testifies under oath that her only concern is honoring her sister's true wishes, and we can then play a recording of her discussing the $385,000 appraisal and how much she stands to gain, that's devastating to her credibility. A witness who lies about their motives is a witness who can't be trusted about anything. So I need her to testify first. Exactly. She needs to take the stand and commit to a version of events. Under oath. And then we introduce the recordings. That's the sequence. You don't play your hand before they've committed. This was the strategy. Let them testify. Let them commit. Let them build their entire case on a foundation of lies told under oath. And then, not before, collapse the foundation with their own words. The second year was different from the first. The first year had been about survival, enduring the shock, the grief, the legal assault, the financial drain. The second year was about preparation. The hearing had been delayed, rescheduled twice, once because Dennis Hargrove requested additional time to review medical records, once because the court's calendar was backed up and the new date was set for early March of the following year. Almost 24 months since Mom's death. 747 days, if you wanted to be precise, and I was precise about it because every single one of those days was another recording. During that second year, I became someone I didn't fully recognize. Not in a dramatic, movie montage way. I didn't take up martial arts or start wearing all black or develop a dark alter ego. I became quieter, more watchful. I developed an almost clinical detachment during interactions with Carol and Frank, observing them the way a naturalist observes animals, cataloging behaviors, patterns tells. When Carol ramped up the emotional manipulation, I noted the specific phrases she recycled. When Frank made one of his just thinking out loud comments about money, I noted the context and the exact wording. When Derek or Troy, who had largely stayed out of things during the first year, started getting more involved as the hearing approached, I noted their involvement too. Troy surfaced in October of that second year. He'd been the invisible cousin up to that point, the one who'd been on a golf trip when Mom died, the one who'd never visited, the one who Carol had apparently kept out of the direct conflict. But as the hearing date approached, Troy started showing up at family dinners that Carol organized, family reconciliation dinners, she called them, held at a restaurant called the Old Mohawk in German Village. Because Carol apparently believed that garlic burgers and craft beer could undo a year of litigation. I went to the first one. I went to all of them. I sat at the table, ordered something small, and recorded everything. Troy was 34. He looked like a taller, less focused version of Derek, same brown eyes, same jawline, but with a restlessness about him, like he was always 2 thoughts away from wherever he actually was. He sold medical devices, or at least that's what he told me. At that first dinner, he leaned across the table with a smile that was supposed to be disarming and said, "Nina, I just want you to know I'm on your side in this. I think Mom's being ridiculous. But you know how she gets." He called Carol Mom in front of me. That was interesting. Not Aunt Carol. Mom. Like he was establishing a closeness that didn't actually exist, trying to signal that he was part of the nuclear unit and I was the outsider. I said, "That's generous of you, Troy. Have you talked to your mom about dropping the suit?" "Oh, she won't listen to me. But I figured if it goes to court, I'll just testify that I support the will. That it should stand as written. That way you're covered." Something about the way he said it triggered my alarm. Not because the words were wrong, but because the tone was too smooth. Too rehearsed. Like someone had told him exactly what to say and when to say it. Thanks, Troy. I appreciate that. 2 weeks later, at the second reconciliation dinner, Troy sat next to me and lowered his voice. "Hey, Nina, can I ask you something? Off the record." "Sure. If Carol offered you a settlement, like a fair split, would you take it? Because I've been trying to talk her down, and I think if you showed some flexibility, we could end this without the hearing." I looked at him. His eyes were sincere. Or they looked sincere. And I thought, he's not here to help me. He's here to gauge my willingness to settle and then report back to Carol. He's a scout, just like Derek was in the first year, but more subtle. "I'm not going to settle, Troy. The will is clear." Mom was lucid. "I'm not giving away my mother's house because your mom filed a meritless lawsuit." Troy's expression flickered, a microsecond of something hard, there and gone. Then the smile came back. "Fair enough. Just thought I'd ask." I went home that night and listened to the recording. At the 14-minute mark, Troy said, "I've been trying to talk her down, and I think if you showed some flexibility, we could end this without the hearing." Which directly contradicted his earlier claim that he was on my side and would testify in support of the will. If he was going to testify for the will, why was he pressure testing me about a settlement? The answer was obvious. He wasn't going to testify for the will. He was going to testify for whatever helped Carol's case. And when he got on the stand and said under oath that he believed the will should stand, I'd have the recording of him trying to broker a settlement behind my back. Derek, meanwhile, had gotten more aggressive. The polite scout from the first year had evolved into something sharper. He showed up at the house one afternoon in January, unannounced, which was a violation of the protective order if he'd come within 100 yards, but the order technically only applied to Carol, and I hadn't thought to extend it to the rest of them. Something to fix, but too late now. Derek stood on the front porch and said, "Nina, I need to talk to you about something serious." I let him in. I always let them in. The recordings were more valuable than the satisfaction of shutting the door. He sat on the couch, Mom's couch, and ran his hands over his face. He looked tired. Genuinely tired, not performed tired. He said, "I think Mom's making a mistake with this lawsuit. I think it's going to blow up in her face. But she won't listen to me, and Frank's encouraging her, and Troy's playing both sides, and I'm stuck in the middle." This was the most honest Derek had ever been with me. And it was also, I suspected, a new angle of manipulation. But I let him talk. She really believes Mom promised her the house. She's been telling that story for so long that I think she's convinced herself it's true. Like, she's not lying in her own head. She genuinely remembers it differently than what actually happened. Carol remembers a lot of things differently, I said. I know she does. But here's the thing, if this goes to hearing and she testifies, she's going to say what she believes. And Dennis is going to back her up. And the judge is going to have to decide between your evidence and her testimony, and it's not as cut and dried as Sandra probably told you. What do you mean? I mean, judges are people. They see these family cases all day long. Sister against daughter. They know that the person who had the most access to the dying parent usually gets the benefit of the doubt from the parent, and that doesn't always mean the will reflects what the parent would have wanted in a neutral moment. Carol's going to argue that you were the last person Mom talked to, and that you had every opportunity to shape her final decisions. That landed. Not because it was true, it was a distortion, a lawyer's argument dressed up in casual language, but because it was the exact argument Dennis Hargrove was going to make in court, and hearing it from Derek meant the strategy was coordinated. They'd discussed this. They'd workshopped it. Derek was softening me up, making me doubt my position, making the courtroom feel like a coin toss even though the evidence was overwhelmingly on my side. "Derek," I said, "are you telling me this because you're genuinely concerned about me, or because your mom sent you to rattle me before the hearing?" He looked at me for a long time. Then he stood up, buttoned his coat, and said, "I'm telling you this because I don't want to watch my family destroy itself over money my mom doesn't even need." He left. I checked the recording. 34 minutes. And right there, at minute 28, he'd said, "She really believes Mom promised her the house." Which was, from a legal standpoint, an admission that Carol's case rested on a belief, not on evidence, not on documentation, not on anything that could be verified or proven. A belief. And in the context of a probate contest where the burden of proof was on the challenger, that was a devastating concession. By the time February arrived, I had 112 recordings. Not all of them were gold, some were just mundane conversations, Carol calling to check in, Frank making small talk about the weather before pivoting to the house. But threaded through the mundane were these moments of absolute, self-incriminating clarity. Moments where they forgot I might be recording. Moments where the mask slipped. The hearing was set for March 8th. A Monday. 23 months and change since Mom had died. I spent the final week listening to the recordings, organizing them, tagging the strongest moments with timestamps and summaries. I made a spreadsheet because of course I did. I was my mother's daughter, and Mom loved a spreadsheet with columns for date, participants, duration, key quotes, and legal relevance. Sandra reviewed it and told me, quietly, "This is the most thorough evidence preparation I've seen in 20 years of practice." I asked her if we were going to win. She said, "I don't use that word. But I will tell you this. When your aunt takes the stand on Monday and swears to tell the truth, she's going to tell a story. And you're going to have the unedited audio of her telling a completely different story to you, on multiple occasions, over the course of 2 years. The judge will hear both. And judges are very, very good at recognizing perjury when it's laid out this clearly. The night before the hearing, I went to the house on Greenfield Lane. I sat in Mom's reading chair, the sagging beige one in the corner of the living room that she'd had since I was a baby, and I opened the sealed envelope she'd left me. It was a letter. For pages, written in her careful teacher's handwriting on cream stationery. I'm not going to share all of it. That's mine. But the last paragraph said this. Nina, if Carol comes for what I've left you, do not feel guilty for defending it. This house, this money, everything I've saved, it's not a prize. It's a tool. Use it to build something. Use it to be okay. I chose you because you were there, and because I trust you, and because love should go where love is given. Don't let anyone make you feel ashamed of that. I folded the letter, put it back in the envelope, and set it on the kitchen table where Mom had first shown me the will, 2 years ago, in that gray winter light. Then I went home, set 2 alarms, and slept deeper than I had in months. The Franklin County Probate Court is on the 3rd floor of the Franklin County Courthouse at 373 South High Street, downtown Columbus. I'd been there once before, for the initial hearing, but this time felt different. This time, the hallway was longer, the fluorescent lights were harsher, and the marble floor seemed to amplify every footstep like the building itself was listening. I arrived at 8:15 for a 9 o'clock hearing. Sandra was already there, standing outside courtroom 3B with a leather portfolio under her arm and a calm expression that I'd learned, over 2 years, was her version of battle mode. She was wearing a dark navy suit, minimal jewelry, and her reading glasses were pushed up on top of her head. With her was David Chin, the estate litigation specialist she'd brought in as co-counsel. David was younger than Sandra, early 40s, sharp-featured, with the kind of focused energy that made him seem like he was always 3 moves ahead in a game only he could see. "How are you?" Sandra asked. "I slept well. Surprisingly. Good. That's good." She put her hand on my arm briefly. "Today is going to be long. Probably all day, possibly into tomorrow if Hargrove drags it out. I need you to stay composed. Whatever happens in that room, whatever Carol says, whatever you hear, you sit there and you let us handle it. Can you do that?" "Yes." "Good. David is going to be running the evidence presentation. I'll be doing the direct examination and cross. If you need a break, write it on the notepad I'm going to give you and slide it across the table. Don't whisper. Don't react visibly. The judge will be watching everything." Courtroom 3B was smaller than I expected. Not like the courtrooms on television, no towering wooden bench, no gallery of spectators. It was a functional room with beige walls, a judge's dais at the front, 2 tables facing each other, and about 4 rows of seating behind a wooden railing. There was a court reporter seated to the side of the judge's bench, her fingers resting on the stenography machine. A bailiff stood by the door. Carol was already seated at the opposite table with Dennis Hargrove. She was wearing a soft blue blazer and a pearl necklace, and her hair was done in that honey blonde she'd adopted the previous year. She looked composed, poised, like she was attending a church function, not trying to take her dead sister's house. Frank sat beside her in a dark suit that didn't quite fit his shoulders, the kind of suit you rent for a funeral, stiff and unfamiliar. Derek was behind them in the gallery. Troy was there too, standing against the back wall with his arms crossed, looking like he wished he was anywhere else. Carol saw me come in. Our eyes met for a moment. She gave me a small, tight smile, the kind that says, "I'm still your aunt, and I'm doing this for the right reasons, and you'll understand someday." I looked away and sat down at our table. Judge Callahan entered at 9:02. He was a slight man in his early 60s, with wire-rimmed glasses and a manner that reminded me of a high school principal, patient, but not to be tested. He settled into his chair, reviewed some papers, and addressed the room. "Good morning. This is the matter of the estate of Diane Margaret Calloway, case number 2024, EP 0447. Petitioner is Carol N. Whitfield, née Calloway, contesting the last will and testament of the decedent. Respondent is Nina Elaine Calloway, daughter of the decedent and named beneficiary. Counsel, are we ready to proceed? Both Sandra and Dennis Hargrove confirmed they were ready. Mr. Hargrove, you may call your first witness. Dennis stood. He was taller than I'd expected, maybe 6'1", with gray hair combed back and a baritone voice that carried well in a courtroom. He moved with the ease of someone who'd done this hundreds of times. Your Honor, the petitioner calls Carol Whitfield to the stand. Carol stood, smoothed her blazer, and walked to the witness stand. She placed her left hand on the Bible, raised her right, and swore to tell the truth, the whole truth, and nothing but the truth. She sat down, folded her hands in her lap, and looked at Dennis with an expression of rehearsed sadness. Dennis began. Mrs. Whitfield, can you state your relationship to the decedent? Diane was my older sister. We were 4 years apart. We grew up together in Reynoldsburg, Ohio. We were very close. Were you close in adulthood as well? We were. We spoke on the phone regularly. I visited her often. We celebrated holidays together. She was my best friend, really. I sat very still. Spoke regularly. Visited often. These were lies, but they were the kind of lies that are impossible to disprove with a single piece of evidence. They're small, human, contextual, the kind of lies that build a portrait of a loving relationship that Carol wanted the judge to believe had existed. How did you learn of your sister's estate plan? Dennis asked. Diane told me years ago, I want to say maybe 2015, 2016, that the house would be divided between us when she passed. She said their father had helped with the down payment and that she always intended for it to stay in the family. Both of us. And when did you learn that the will had changed? After she passed. At the reading, when Sandra told us that everything had been left to Nina. I was shocked. I couldn't believe Diane had done that without talking to me first. Dennis paused for effect. The court reporter's fingers moved in a blur of silent keystrokes. Judge Callahan was watching Carol with an expression that was impossible to read, not skeptical, not sympathetic, just attentive. Mrs. Whitfield, in your petition, you've raised concerns about your sister's testamentary capacity at the time the will was executed. Can you explain the basis for those concerns? Carol nodded slowly, like she was gathering the weight of her words. Diane was diagnosed with pancreatic cancer in late January of 2024. She died 6 weeks later, in early March. During those 6 weeks, she was on aggressive chemotherapy. She was on heavy pain medication, opiates, anti-nausea drugs, steroids. Anyone who's been through that with a loved one knows how it changes them. She was confused sometimes. She'd forget conversations we'd had. She'd repeat herself. She was vulnerable, and Nina was the only person with her during those weeks. Are you suggesting that Nina influenced your sister's decisions during that period? I'm suggesting that Nina was in a position to influence her, and that given Diane's condition, the medication, the pain, the emotional stress of facing the end of her life, it's reasonable to question whether the will Diane signed in December truly reflected her wishes, or whether it reflected what Nina wanted her to do. What about the December execution? That was before the diagnosis. Yes, but that's exactly my point, Dennis. Sorry, Mr. Hargrove. The December will was made when Diane was perfectly healthy. It was the last clear expression of her wishes before the cancer. The fact that there was no subsequent update after the diagnosis suggests to me that she didn't have the opportunity or the clarity to reconsider. And I strongly believe, that if she had been given the chance, in a clear state of mind, to think about what was fair to the whole family, she would have made different choices. This was skillfully done. Dennis had walked Carol through a narrative that was internally consistent, emotionally resonant, and specifically designed to create doubt in the judge's mind. The story was, loving sister, shocked by the will, concerned about the deceased's state of mind, not motivated by money, but by a desire to honor what she believed were Mom's true wishes. It was a good story. It was also almost entirely fiction. Dennis had one more question. Mrs. Whitfield, is there anything you'd like the court to understand about your intentions in filing this contest? Carol looked directly at Judge Callahan. Your Honor, I am not doing this for money. I'm doing this because my sister would have wanted her home to stay in the family, all of the family, not just one person. I'm doing this because I love Diane, and I owe it to her memory to make sure her final wishes are honored. I would give up every penny of whatever share I might receive if I could just have my sister back. But I can't. So I'm here to make sure she's heard. It was a good performance. Under oath. Committed. On the record. Sandra stood for cross-examination. I watched her approach the witness stand with a measured pace, not aggressive, not hurried, just deliberate. She had a yellow legal pad in her hand, but I knew she barely needed it. She'd listened to every recording. She'd built her cross from their own words. Mrs. Whitfield, you stated that you and Diane spoke on the phone regularly and that you visited often. Can you tell the court how many times you visited Diane during the 6 weeks she was undergoing cancer treatment? Carol hesitated. Just a beat, but I caught it. I visited, I want to say, several times. 3 or 4 times, perhaps. 3 or 4 times in 6 weeks? It was a very difficult time. I had my own family obligations. But I was in regular phone contact. Including with Diane herself? Yes. How many phone calls would you estimate you had with your sister during those 6 weeks? I don't have an exact number. Several. Would it be fewer than 10? Carol's jaw tightened. I suppose it might have been. I wasn't counting. Let me rephrase. During the final 6 weeks of your sister's life, you visited her 3 or 4 times and spoke with her on the phone fewer than 10 times. Is that accurate? I was there for her in other ways. I'm not asking about other ways, Mrs. Whitfield. I'm asking about direct contact during the final 6 weeks of your sister's life. 3 or 4 visits and fewer than 10 phone calls. Yes or no? Yes. But that doesn't mean I didn't. Thank you. Now, you testified that Diane told you, in 2015 or 2016, that the house would be divided between you when she passed. Was this conversation in writing? No. It was a personal conversation. Were there any other witnesses? Just me and Diane. So it's your word alone that this conversation took place. It's my memory of a conversation with my sister. I don't see why that's. I'm not disputing your memory, Mrs. Whitfield. I'm establishing the evidentiary basis of your claim. You're asking this court to override a legally executed will based on a private conversation that no one else witnessed and that was never documented in any way. Is that correct? Dennis objected. Argumentative, Your Honor. Sustained, Judge Callahan said. Ms. Kohler, rephrase. Sandra nodded. Mrs. Whitfield, did Diane ever mention this alleged promise in any document, email, text message, or written communication of any kind? No. It was just something we discussed. Did she ever repeat this promise to anyone else? To Frank? To Derek? To Troy? Not that I'm aware of. So the only evidence that Diane promised you the house is your own testimony about a private conversation that occurred approximately 8 to 9 years ago. Yes, that's my testimony. Sandra made a note on her legal pad. I knew what she was doing. She was establishing, for the record, that Carol's entire case rested on an uncorroborated memory. Then she was going to pull the rug out. Mrs. Whitfield, you stated under oath that you are not doing this for money. Is that correct? That's correct. You told this court that you would give up every penny if you could have your sister back. Yes. Sandra paused. She looked at Judge Callahan. Your Honor, at this time, the respondent wishes to introduce authenticated audio recordings into evidence for the purpose of impeaching the witness's testimony regarding her stated intentions and her characterization of communications with the decedent. Dennis was on his feet immediately. Objection, Your Honor. These recordings, if they even exist, were made without the witness's knowledge or consent and are being introduced for the first time at this hearing without proper disclosure. Judge Callahan looked at Sandra. Ms. Kohler. Your Honor, the recordings were made by my client, who was a participant in every recorded conversation in the state of Ohio, which is a one-party consent jurisdiction. They are therefore legally obtained. As for disclosure, they were included in our pretrial evidence submission filed on February 28th, which I believe counsel received. She handed a document to the judge, who reviewed it briefly. Dennis Hargrove's face changed, just slightly, just for a moment, when he saw the date. He'd received the filing. He'd had a week to review it. Either he'd missed it in the stack of documents, or he'd seen it and chosen not to prepare Carol for it. Either way, it was too late. I'll allow it, Judge Callahan said. Mr. Hargrove, do you wish to review the recordings before they're played? Yes, Your Honor, I'd like a moment to. The recordings were disclosed in the pretrial filing. You've had 8 days. I'm going to allow the respondent to proceed. You may object to specific recordings as they're played, and I'll rule on each one. Dennis sat down. He leaned toward Carol and whispered something. She was looking at Sandra with an expression that I'd never seen on her before, not anger, not sadness, but the raw, animal fear of someone who has just realized that the ground beneath them is not solid. Sandra turned back to Carol. Mrs. Whitfield, I'm going to play a series of recordings for you and for the court. I'd like you to listen carefully and then confirm or deny that the voice on the recording is yours. She nodded to David Chin, who was sitting at our table with the laptop connected to the courtroom's audio system. He tapped a key and the room filled with Carol's voice. The first recording was from March 17th, the first one. The night Carol had called me at 11:30 p.m., 12 days after Mom's funeral. Her voice came through the courtroom speakers with a clarity that was almost painful. Every inflection, every calculated pause, every false note of warmth rendered in high fidelity. Nina, I'm not trying to take anything from you. I just want what Mom would have wanted if she'd been thinking clearly. The courtroom was utterly silent. Carol sat rigid in the witness chair, her hands gripping the armrests. Sandra paused the recording. Mrs. Whitfield, is that your voice? Yes. And in this recording, made on March 17, 2024, you state, and I'm quoting directly, I'm not trying to take anything from you. Is that accurate? Yes, but I was just confirming the statement. Now, let's continue. David played the next clip. Same recording, about 2 minutes later. My voice asking, Carol, did Mom ever tell you that she wanted to leave you part of the estate? And then Carol's response. She told me years ago that the house would be half mine. She promised me, Nina. When Dad died, she said the house belonged to both of us. Sandra paused. So here, Mrs. Whitfield, you claim that your mother promised you the house. Specifically, the house would be half mine. A direct promise. Not a vague conversation, not an impression, a promise. Is that your voice making that claim? Yes. Now, let me direct your attention to a recording from May 14, 2024. David cued the next clip. This was the one from the living room. Frank's voice caught clearly, thinking he was speaking privately to Carol while my phone sat on the coffee table. The appraiser said the house is worth at least $385. If we can get Nina to settle for half, that's close to $200,000 right there. Plus the retirement accounts split 4 ways. That's another, $70,000, $80,000 each? This could actually work out. Carol's voice, shushing him. Frank, not here. Sandra let the clip finish. The silence in the courtroom had a different quality now, heavier, charged. Judge Callahan had shifted forward slightly in his chair. Even the court reporter's fingers seemed to have slowed, as if she wanted to make sure she captured every syllable. Mrs. Whitfield, the male voice on that recording is that your husband, Frank Whitfield. Yes. And he is discussing, in specific dollar amounts, the financial outcome of this lawsuit. He references a house appraisal of $385,000, a settlement that would yield close to $200,000, and a division of retirement accounts worth $70,000 to $80,000 each. Mrs. Whitfield, you testified under oath moments ago, and I quote, I am not doing this for money. How do you reconcile that testimony with your husband's detailed financial analysis of the expected proceeds of this lawsuit? Dennis objected again. Your Honor, counsel is badgering the witness. Mr. Whitfield's statements are not Mrs. Whitfield's statements. Judge Callahan considered this. I'll allow the question, but Ms. Kohler, I want you to stay focused on the witness's own statements. Sandra nodded. Of course, Your Honor. Let me redirect. She looked at Carol. Mrs. Whitfield, your husband, with whom you share a household, a bank account, and a legal strategy, is heard on this recording calculating the expected financial gain from this lawsuit. Were you aware of these calculations? Carol's composure was cracking. Her fingers were white on the armrests. Frank says things. He thinks out loud. That doesn't mean. I'm not asking what Frank means. I'm asking if you were aware that he had obtained an appraisal of the house and was calculating your share of the proceeds. We discussed the house value as part of understanding the. Yes or no, Mrs. Whitfield? Were you aware? Yes. But knowing the value of the house is not the same as. Thank you. Now let me play another recording for you. David cued the next one. June of the first year. Derek on the back porch. His voice, young and callous in that particular way that confident people are callous when they think no one is documenting them. My mom's just trying to get what's fair. Sandra paused. Mrs. Whitfield, your son Derek, who is present in this courtroom today, states here that your lawsuit is about getting what's fair. He does not say it's about your sister's wishes. He does not say it's about honoring Diane's memory. He says it's about fairness, which, in context, clearly refers to a financial distribution. Would you agree? He misspoke. He didn't mean. He said it. It's on recording. Would you like me to play it again? No. Moving on. Let me direct the court's attention to a recording from December 25th, 2024. Christmas Day. David played it. Carol's voice, soft and performative. I miss her. My voice, I know you do. Carol, I keep thinking about what Mom would want. And I can't let this go. Not because of the money. Because of what's right. Sandra paused the recording. The phrase hung in the air, not because of the money. Mrs. Whitfield, you said on December 25th, Christmas Day, and I quote exactly, I can't let this go. Not because of the money. Because of what's right. You said this to my client, Nina Calloway. And yet, in the recordings we've heard today, your husband is calculating a $200,000 plus payout. Your son acknowledges the lawsuit is about financial fairness, and you yourself told Nina in March that Mom promised you the house. Which of these statements is true, Mrs. Whitfield? Because they cannot all be true simultaneously. Carol opened her mouth. Closed it. Her eyes were wet, but I didn't know if the tears were real or performed, and by that point, I'm not sure it mattered. The courtroom was waiting. All of them are true in their own way. I did miss Diane. I do believe the house should be shared. And Frank talking about money doesn't change it doesn't change what you testified under oath, Mrs. Whitfield. You told this court, 12 minutes ago, that you would give up every penny to have your sister back. And yet for the past 23 months, you have spent tens of thousands of dollars in legal fees, hired a probate litigation specialist, filed a motion to depose my client's oncologist, attempted to change the locks on the house with a hired locksmith, and had your husband obtain a property appraisal, all while telling my client, on recorded audio, that it was not about the money. Your Honor, I request permission to play 2 additional recordings that speak directly to the witness's credibility regarding her stated intentions. Judge Callahan nodded. Go ahead. The first was the restaurant recording from April. Carol over Chardonnay, laying out the financial pressure strategy. The legal fees are going to eat you alive. Sandra is good, but she's not cheap. And Dennis has filed enough motions that you're going to be paying for months just to respond. How long can you afford this? And then, the line that burned the hottest. Mom's will is going to be thrown out. I have a strong case. The medical evidence is on my side, and Dennis has found a witness, someone who saw Mom in her final weeks and is willing to testify that she was confused, that she wasn't making her own decisions. Sandra paused. Mrs. Whitfield, in this recording from April 2024, you told my client, again, on audio, that your case was strong, that the medical evidence was on your side, and that you had found a witness willing to testify. You also told her that if the case went to trial, she would lose and get nothing. This doesn't sound like someone who believes they're simply asking a court to honor their sister's wishes. This sounds like someone who is confident of victory and who is using the legal system as leverage. Would you agree? No. I was trying to encourage Nina to settle to avoid the pain of a trial. You were threatening her. You told her she would get nothing. That's not encouragement, Mrs. Whitfield. That's a threat. Objection, Dennis said, but weaker now. Less certain. Overruled, Judge Callahan said. And I noticed for the first time since the hearing began that the judge had stopped looking at Dennis when he made rulings. He was looking at Carol, studying her. Sandra had one more. The last recording she played was from the phone call the night Carol learned about the protective order, the one where she'd said, barely audibly, "You have no idea what I'm capable of," right before hanging up. David played it. The courtroom was so quiet that Carol's whispered threat came through the speakers like a secret being shouted. "You have no idea what I'm capable of." Sandra let the silence sit for 3 full seconds. Then, "Mrs. Whitfield, is that your voice at the end of this recording?" Carol didn't answer. She was staring at the table in front of her, and I could see her hands trembling. "Your Honor," Sandra said, turning to the judge, "the respondent rests her cross-examination. The evidence before this court is clear. The petitioner has testified under oath that her only motivation is love for her sister and a desire to honor her wishes. The recordings, made over a period of nearly 2 years by the respondent, demonstrate conclusively that the petitioner's actual motivation is financial gain, that she discussed the financial specifics of the anticipated outcome with her husband, that she attempted to use the legal process to pressure the respondent into a settlement, that she attempted to physically take control of the property by hiring a locksmith, and that she made threatening statements to the respondent. We respectfully request that this court dismiss the petition in its entirety and award the respondent her attorney's fees." Dennis Hargrove stood. He was trying to project confidence, but the energy in the room had shifted so dramatically that it was like watching someone try to conduct an orchestra after all the musicians had left. He called Frank to the stand, and Frank testified, haltingly, unconvincingly, that his comments about the $385,000 appraisal had been casual and not serious. But the recording was already in evidence, and Frank's attempt to walk it back only made him look more dishonest. Dennis called Derek. Derek, to his credit, was slightly more composed than Frank, but when Sandra played back his "my mom's just trying to get what's fair" clip and asked him to explain it, he stammered through an answer about how fair could mean different things, and it was obvious, even to the bailiff standing by the door, that he was making it up as he went. Dennis did not call Troy. And I knew why. Troy's recordings were the most damning of all, the ones where he pretended to support the will while simultaneously trying to broker a settlement, the ones where he was clearly operating as Carol's agent. Putting him on the stand would have been suicide. Hargrove called his medical expert, a geriatric psychiatrist who testified about the cognitive effects of cancer treatment and pain medication. Sandra cross-examined him effectively, establishing that he had never examined Mom, had only reviewed selected medical records provided by Hargrove's office, and could not opine on Mom's specific cognitive state at the time the will was executed. The hearing lasted until 4:30 that afternoon. Judge Callahan announced that he would issue a written ruling within 30 days. He thanked everyone for their patience, reminded the parties that the protective order remained in effect, and adjourned. I walked out of the courtroom behind Sandra and David. The hallway was empty except for a few lawyers walking with purpose in other directions. Carol and her family had left through a different exit. I didn't see them, and I was glad. Sandra turned to me in the hallway and said, "It went exactly as it needed to. Are we going to win?" Sandra looked at me with an expression I'd seen before, the one she wore when she was choosing her words very carefully. "I don't predict judicial outcomes. But I will say this. Your aunt testified under oath that she was not motivated by money." And then we played 14 recordings in which she, her husband, and her sons discussed this lawsuit almost exclusively in financial terms. A judge doesn't need to be a legal scholar to recognize that the witness's testimony was contradicted by her own recorded words. David Chin, standing behind Sandra, added something that I hadn't expected. "There's something else you should be prepared for. If the judge rules in your favor, and I believe he will, those recordings don't just win you the civil case. They document what could be construed as perjury, fraud, and attempted theft by deception. The Franklin County Prosecutor's Office could take an interest if someone brings it to their attention." Sandra gave David a look. He shrugged. "I'm just saying it's on the table," David said. We walked to the parking garage in silence. The late afternoon light was golden, the kind of light that makes even downtown Columbus look almost beautiful. I got in my car and sat behind the wheel for a long time, not starting the engine, just breathing. 23 months. 747 days of grief, and recording and pretending I wasn't dying inside while my mother's sister tried to dismantle everything my mother had built. And today, in a small courtroom on the 3rd floor of the Franklin County Courthouse, they'd heard it all. Every lie, every greedy calculation, every threat, in Carol's own voice. I started the car and drove to the house on Greenfield Lane. I sat in Mom's reading chair and cried. Not because I was sad. Because it was over. Or almost over. The ruling was still 30 days away. The 30 days were almost worse than the 2 years that came before them. Because during those 2 years, I had a mission. I had a purpose. Every interaction with Carol was a data point, every phone call was evidence, every dinner was an intelligence operation. I was doing something. And doing something, even something painful, even something exhausting, is infinitely more bearable than waiting for someone else to do something for you. Judge Callahan's ruling would arrive by mail and by email. Sandra had told me to expect it on a weekday, probably a Tuesday or Wednesday, because judges tend to issue written opinions in the middle of the week when the court's administrative pace is slower. She said not to obsess over it. She said to go about my life. She said it like it was easy. During those 30 days, I heard nothing from Carol or her family. Nothing. No phone calls, no texts, no unannounced visits. The silence was so complete that it felt aggressive, like the quiet after a car crash, when your ears are ringing and you can't tell if the world is actually silent or if you've just lost the ability to hear it. Dennis Hargrove filed no new motions. He submitted no additional evidence. He didn't even request an extension, which told me everything I needed to know about how he thought the hearing had gone. A confident attorney doesn't go quiet after a hearing. A defeated attorney does. I went to work. I went to the house on Greenfield Lane every day after work and sat in the living room with Whitman and Dickinson, reading Mom's books, taking care of the plants, keeping the house alive the way Mom would have wanted. I did not call Sandra every day to ask if the ruling had come. I called her every other day, which was almost as bad, and she tolerated it with the patience of someone who understood that I was not calling because I didn't trust the legal process, but because I had nothing else to hold on to. The ruling arrived on a Thursday, April 10th, 22 days after the hearing. I was at my apartment, the smaller, more expensive one in the part of Grandview I didn't like, when my phone buzzed with an email notification from Sandra's office. The subject line was blank. The body of the email was 2 words, "Call me." I called. Sandra answered on the first ring. Her voice was warm in a way that I hadn't heard since before the lawsuit, like she'd set down a weight she'd been carrying for 2 years. "He ruled in your favor." The petition is dismissed in its entirety. Carol's contest is denied. The will stands as written. You are the sole beneficiary of the estate of Diane Margaret Calloway. The protective order remains in effect until further order of the court. I sat down on my kitchen floor. I didn't mean to. My legs just stopped working. There's more, Sandra said. Read the opinion. I'm going to email it to you right now. But I want to tell you, and I want you to hear this from me before you read it, Judge Callahan's written opinion is not just a dismissal. It is a detailed, point-by-point demolition of your aunt's case. He addresses every claim she made on the stand and contrasts it with the recorded evidence. He uses phrases like directly contradicted, demonstrably false, and the witness's credibility is thoroughly impeached by her own recorded statements. This isn't just a win, Nina. This is a judicial finding that your aunt committed perjury. On the record, I was crying. Not loudly. Not dramatically. Just tears running down my face while I sat on my kitchen floor with the phone pressed to my ear, and Whitman, who had followed me from the bedroom and was now sitting on my feet, purring against my ankle. Sandra continued. He also awarded you attorney's fees. Full amount. Every dollar we've billed over the past 23 months is to be paid by Carol Whitfield out of her own personal funds. That's approximately $78,000. I almost laughed. The legal fees that Carol had been counting on to break me, the very weapon she'd wielded, had been turned around and pointed back at her. One more thing, Sandra said. Judge Callahan included in his opinion a recommendation, not an order, but a formal recommendation, that the Franklin County Prosecutor's Office review the recordings for potential perjury charges. He specifically cited the contradictions between Carol's testimony and the recordings, and he noted that the deliberate nature of the misrepresentations made under oath in a court of law warrants consideration of criminal accountability. He referred it to prosecutors. He included a copy of his opinion and the authenticated recordings in a sealed transmittal to the prosecutor's office. He can't force them to bring charges, that's their decision, but he's made his position very clear. A probate judge doesn't do this lightly. I thanked her. I told her I'd read the opinion. I hung up and then I sat on that kitchen floor for another 20 minutes, petting Whitman, letting it sink in. The opinion was 18 pages long. I read it 3 times that night. Judge Callahan's writing was precise and unsparing. He began with the legal standard for contesting a will in Ohio. The petitioner bears the burden of proving, by clear and convincing evidence, that the testator lacked testamentary capacity or was subject to undue influence. He noted that this is a high bar and that Ohio courts have consistently held that the presumption of validity of a properly executed will is not easily overcome. He then addressed Carol's capacity claim. He described the medical evidence, Dr. Patel's testimony that Mom was one of the most organized and mentally sharp patients I've treated, the will execution witnesses who confirmed Mom was alert, articulate, and deliberate, and the December execution date itself, which preceded the diagnosis by 2 months. He wrote, "The petitioner has failed to produce any credible medical evidence that the decedent lacked testamentary capacity." The single witness offered by the petitioner, Ms. Patricia Holloway, had contact with the decedent on 3 occasions totaling approximately 45 minutes. Her testimony regarding the decedent's cognitive state is conclusively outweighed by the testimony of the decedent's treating oncologist, the attorney who prepared the will, and the 2 witnesses to the execution. Then he addressed the recordings. This was the section I read 5 times. The court has reviewed 14 authenticated audio recordings submitted by the respondent, spanning a period from March 2024 to February 2026. These recordings capture conversations between the respondent and the petitioner, the respondent and Frank Whitfield, the respondent and Derek Whitfield, and the respondent and Troy Whitfield. The court finds these recordings to be authentic, legally obtained under Ohio's one-party consent statute, and highly probative of the issues before this court. He laid out the specific contradictions, one by one, recording by recording. He quoted Carol's testimony, "I am not doing this for money," and then quoted Frank discussing the $385,000 appraisal and the expected $200,000 share. He quoted Carol's testimony about her close relationship with Mom. "We were very close," and then noted the evidence that Carol had visited Mom only 3 or 4 times during her final 6 weeks and made fewer than 10 phone calls. He quoted Carol's testimony that Mom had promised her the house, and then noted that this promise existed only in Carol's uncorroborated memory and was contradicted by every piece of documentary evidence in the estate file. And then, the paragraph that I later learned was cited in 2 Ohio legal blogs and 1 national estate planning newsletter. This court finds that the petitioner, Carol N. Whitfield, testified falsely under oath regarding her motivations for filing this contest and her understanding of the decedent's wishes. The recordings submitted by the respondent do not merely contradict the petitioner's testimony, they obliterate it. The petitioner told this court that her sole motivation was love for her sister and a desire to honor her memory. The recordings reveal that the petitioner's actual motivation was financial gain, that she and her husband discussed the financial specifics of the anticipated outcome in detail, that she attempted to use the legal process and the threat of financial exhaustion to pressure the respondent into a settlement, and that she made threatening statements to the respondent. The contrast between the petitioner's sworn testimony and her recorded statements is not a matter of interpretation or perspective. It is a matter of documented fact. The petitioner lied to this court, and she did so repeatedly and deliberately. I stared at those words on my screen. The petitioner lied to this court, and she did so repeatedly and deliberately. A sitting probate judge, in a written legal opinion, had said that about my aunt. In those exact words. The opinion concluded with the dismissal of the petition, the award of attorney's fees, and the sealed transmittal to the prosecutor's office. The last line read, "The will of Diane Margaret Calloway is affirmed in its entirety. The respondent, Nina Elaine Calloway, is hereby directed to proceed with the administration of the estate in accordance with the decedent's expressed wishes." I printed the opinion. I put it in a folder. I put the folder in my bag. And the next morning, I drove to the house on Greenfield Lane and sat in Mom's reading chair and held the opinion in my hands and said, out loud, to the empty room, "It's over, Mom. It's actually over." The estate unfroze within a week of the ruling. Sandra filed the necessary paperwork, the probate court issued its final orders, and I was able to access the accounts for the first time since Mom's death. I remember logging into the bank for the first time and seeing the balances, the retirement accounts, the insurance proceeds, everything, and feeling nothing. Not relief. Not joy. Just a flat, wide-open emptiness where the anxiety had been, like a riverbed after a flood. The money was real, and it was mine, and my mother had earned every dollar of it, and it had taken 2 years and $78,000 in legal fees and 112 recordings to prove that it should have been mine all along. I paid Sandra's fees. The court had ordered Carol to pay them, but I wasn't going to wait for Carol to come through, if she even could. I had the money now, and I wanted Sandra paid promptly and in full. Sandra's paralegal, Michelle, told me that Sandra had never had a client pay a $78,000 invoice within 48 hours of receiving it. I told Michelle that Sandra had earned it. Carol's check came 3 weeks later. It was late. The court had given her 30 days to pay, and she'd taken every single one of them. The check was for $78,412, the full amount of the attorney's fees, plus a few hundred in court costs. It cleared. I deposited it. And that was the last financial transaction I ever had with my aunt. The prosecutor's office took 4 months to make their decision. I didn't follow it closely, Sandra kept me updated, but I was trying to rebuild something resembling a normal life, and tracking criminal proceedings against my own family members didn't feel like part of that. In August, Sandra called to tell me that the Franklin County Prosecutor's Office had concluded their review and had decided not to bring perjury charges against Carol. I wasn't surprised. Perjury is notoriously difficult to prosecute. You have to prove beyond a reasonable doubt that the person knowingly made a false statement under oath with the intent to deceive, and the defense would argue that Carol's statements were matters of memory, interpretation, and subjective belief, not deliberate falsehoods. A prosecutor has limited resources, and a case involving a family inheritance dispute, even one with strong evidence, is not the kind of thing that typically rises to the level of criminal prosecution. I understood that. I didn't like it, but I understood it. However, the prosecutor's office had done something else. They'd sent a formal notification to Dennis Hargrove, not a charge, not a subpoena, but a notification that the recordings and Judge Callahan's opinion had been reviewed and that the conduct documented therein may be relevant to future inquiries. It was a polite, bureaucratic way of saying, "We see what happened here, and if you or your client ever do anything like this again, we'll be watching." Dennis Hargrove reportedly told Carol that it was a non-event. I suspected it felt like more of an event to him than he let on. Frank called me once, about a month after the ruling. It was a Saturday afternoon, and I was at the house, repotting some of Mom's plants that had gotten too big for their containers. I didn't recognize the number, but I answered old habits. "Nina, it's Frank." I almost hung up, but something in his voice stopped me. He didn't sound like the Frank from the recordings, the one who calculated dollar figures and discussed strategy in my living room. He sounded tired, deflated, like someone who'd been told a truth about himself that he couldn't unhear. "What do you want, Frank?" A long pause. I wanted to say I'm sorry for what I said about the house, about the money. I wasn't thinking about what it sounded like. I was just running numbers because that's what I do, and I didn't mean for it to. "Frank, you said those things in my living room, in my mother's house, while your wife was suing me for everything my mother left me. You don't get to apologize for how it sounded. You can only apologize for what it was. And what it was you and your wife planning to take my inheritance and calculating exactly how much you'd get." Another pause. Longer. I know that's what it was. "Is Carol sorry?" Silence. "Frank, is Carol sorry?" "She's angry, Nina. She's very angry. She thinks she thinks what you did was worse than anything she did. What I did was document your family trying to steal from me. That's not worse. That's self-defense. She says you betrayed her trust. Carol sued me 11 days after her sister's funeral and spent 2 years trying to take my mother's house. Trust was gone before I ever pressed record." Frank sighed. It was a heavy sound, the kind that comes from somewhere deep and tired. "I know. I'm not going to argue with you. I just wanted to say I was sorry, and I wanted you to hear it from me directly. Not through Carol, not through Derek. From me." "Okay. I hear you, Frank." I hung up. I went back to repotting Mom's plants. And I didn't hear from Frank again. Derek reached out twice over the following months. The first time was a text long, rambling, semi-apologetic, full of the word "just" in all the places people put it when they're trying to minimize their own responsibility. I was just doing what my mom asked. I was just trying to help. I didn't just mean it the way it sounded. I read it and didn't respond. The second time was another text, about 3 months later. Shorter this time. "Nina, I know you probably hate me. I just want you to know that I told my mom from the beginning that this was a bad idea. I told her it would blow up. She didn't listen. I'm sorry it came to this." I read that one twice. It was probably partially true. Derek had said as much to me on the recording, that Carol was making a mistake and that he was stuck in the middle. But stuck in the middle wasn't the same as refused to participate. He'd shown up at the house, he'd made the phone calls, he'd said the words, and he'd done it all with the awareness that it was wrong. Knowing something is wrong and doing it anyway isn't being stuck. It's choosing. I never responded to Derek. I never heard from Troy at all. Troy, in my estimation, had been the smartest of all of them. He'd kept his distance, played both sides, and slipped away before the recordings could catch him saying anything explicitly incriminating. He was the one who got out cleanest, which in a family like this probably counted as a victory. Carol. I need to talk about Carol. I didn't speak to Carol after the ruling. Not once. She didn't call, she didn't text, she didn't show up at the house. The protective order was still technically in effect, but even if it hadn't been, I don't think she would have come. Because Carol had lost something in that courtroom that went beyond the lawsuit. She'd lost the narrative. For 23 months, Carol had been telling herself a story. The story was that Mom had promised her the house. That I'd taken advantage of Mom's illness. That Carol was the righteous one, fighting for fairness and family and justice. It was a story that let her sleep at night, that justified every cruel thing she'd done, that made the locksmith and the landlord call and the legal fees and the public humiliation of her own niece feel like necessary sacrifices in service of a greater good. Judge Callahan's opinion destroyed that story. Not in a subtle way. Not in a way that Carol could reframe or explain away. He'd put it in writing, in a legal document filed with the court, that she had lied under oath. That her motivations were financial. That her claims about Mom's wishes were unsupported and contradicted by every available piece of evidence. That her own recorded words proved it. I heard through Sandra, who heard through Dennis Hargrove's office, that Carol had not taken it well. She'd apparently told Dennis that the recordings were an invasion of privacy and that Judge Callahan was biased. Dennis had apparently told her that neither of those arguments was viable and that she should accept the ruling and move on. Carol had reportedly responded by firing Dennis Hargrove and hiring a new attorney to explore an appeal. The appeal went nowhere. Sandra had warned me this might happen, and she was right. The new attorney filed a notice of appeal, but the Ohio Court of Appeals requires a showing of reversible error, a specific legal mistake by the trial court that affected the outcome. There was no reversible error. The trial had been procedurally flawless. Judge Callahan had given Carol every opportunity to present her case, had admitted all of her evidence, and had ruled against her on the merits. The appellate court dismissed the appeal within 4 months. Carol was ordered to pay my appellate attorney's fees as well, another $12,000. I don't know what that money did to Carol and Frank's finances. I don't know if Frank lost his logistics job, or if the $90,000 plus in total legal fees they owed forced them to sell their house in Newark, or if the strain of the whole thing damaged their marriage. I heard rumors, through the same chain of Sandra heard through Hargrove's office, that Frank had moved out at some point in the fall of that year. I heard that Derek had stopped speaking to Carol for a while. I heard that Troy, who had always been the most emotionally detached of the cousins, had washed his hands of the entire situation and stopped returning Carol's calls. I don't know how much of that is true. I didn't investigate. I didn't ask. I didn't send anyone to find out. Because by that point, I had learned something about grief and family and the specific, quiet violence that people are capable of when they convince themselves they deserve something. The aftermath is not your responsibility. You don't owe the people who hurt you a relationship. You don't owe them forgiveness. You don't owe them access to your life. You owe them nothing. And the moment you understand that, truly understand it, in your chest, in your bones, is the moment you start to heal. The house on Greenfield Lane became mine completely that summer. The deed was transferred, the accounts were consolidated, and for the first time since Mom died, I could walk into that house and know, not hope, not believe, but know that it was mine. Not the bank's. Not the court's. Not Carol's. Mine. I made some changes, but not many. I repainted the living room, a warm off-white that Mom would have liked. I replaced the carpets in the hallway, which had been worn thin by decades of footsteps. I updated the kitchen appliances because the refrigerator was from 2005 and the dishwasher made a sound like a dying animal. But I kept the bookshelves. I kept the reading chair. I kept the dogwood tree. I kept Mom's mug collection, which filled 2 entire kitchen cabinets. She'd been collecting them since the 1980s, picking them up at craft fairs and bookshop gift shops and roadside stands in small towns across Ohio. Every mug had a story, and even though I didn't know all of them, I couldn't bring myself to get rid of a single one. Whitman and Dickinson adjusted to the new normal, which for cats mostly means sleeping in different sunbeams and occasionally knocking something off a shelf to remind you who's really in charge. Dickinson, the black one, took to sitting on the kitchen counter every morning while I made coffee, watching me with this expression of feline indifference that I found inexplicably comforting. Whitman, the tabby, claimed Mom's reading chair as his permanent territory, which felt right. Mom would have wanted it that way. I opened the sealed letter again, one night about 6 months after the ruling. I sat at the kitchen table, always the same table, and read all 4 pages. The letter was full of the kinds of things you'd expect from a mother writing to her daughter: pride, love, advice about the future, a gentle instruction to not let the world make you hard. But there was one line that I kept coming back to, a line I hadn't fully absorbed the first time I read it, in the chaos of the night before the hearing. The people who try to take what isn't theirs will always tell you they're doing it for the right reasons. Don't argue with them about their reasons. Just keep the receipts. Mom had always had a way with words. She'd spent 32 years teaching teenagers how to parse language, how to spot a weak argument, how to recognize when someone was using rhetoric to hide an ulterior motive. And in that one sentence, just keep the receipts, she'd given me everything I needed. Not literally, of course. She couldn't have known about the recordings, about the 2 years, about the courtroom. But she knew me. She knew I was methodical, that I was patient, that I had her instinct for noticing what people said and holding on to it. She trusted that I would handle whatever came. I miss her every day. That hasn't changed. I don't think it ever will. But the grief has shifted, the way grief does when you survive the thing that was trying to destroy you alongside it. It's not the sharp, breathless pain of those first months. It's a quieter thing now, a presence, like the house itself. Always there. Always familiar. Sometimes, when the light hits the kitchen table at the right angle in the late afternoon, I can almost feel her sitting across from me, sipping her lemon tea, telling me about a book she just read, asking about my day, being my mother. And the people who tried to take this from me, the house, the money, the memory of who my mother was and what she wanted, they're out there somewhere, living with the consequences of their own choices. Dealing with whatever their lives look like after a probate judge put it in writing that they lied, that they perjured themselves, that their own recorded words buried them. I didn't ruin Carol's life. I didn't seek revenge in the way people imagine revenge. There was no dramatic confrontation, no public exposure, no viral moment of humiliation. What I did was simpler and, I think, more devastating. I told the truth. I let them tell their own truth over and over for 2 years, and then I played it back for a judge. The recordings didn't embellish. They didn't edit. They didn't spin. They just captured, faithfully and completely, the sound of people who thought they were untouchable, proving, in their own voices, that they weren't. Mom used to say, and I'm going to end with this, because it's the thing I think about most when I think about those 2 years: justice doesn't always come with thunder and lightning, Nina. Sometimes it just comes with a quiet click. The sound of someone pressing record at exactly the right moment. She was right. She was always right about the important things. If this story kept you hooked, don't forget to like the video, subscribe to the channel, and share your thoughts below. Thanks for watching.